Welcome back. This is still the Polity reaching you from Abuja. I've been joined in the studio now by two guests to do justice to the matter of the Chicago State saga involving the veracity of President Bola Ahmed Tinubu's certificate or diploma from that university. Is the main case ongoing and brought by the PDP presidential candidate for the February 2023 elections, former Vice President Atiku Abubakar. To my left, I have Mr. Destiny Ehidiamen. He's a legal practitioner. And to my right, I have Mr. Jose Anene. He is a PDP member and a policy analyst. Good afternoon and welcome to the program, gentlemen.
Good afternoon.
Good to have you. Yeah. All right, I'd like to start with you, Mr. Anene. We know that your candidate brought this case up, and some people say is raising the dust. So I'd like to know, from what we've seen so far, the last thing we've seen was the deposition of the CSU official. I'd like you to, really point us out so that we start on the note of understanding what's happening. What are the key takeaways from that deposition that you would like, or your party would want Nigerians to be aware of or take, serious attention, pay serious attention to?
Yeah, so thank you for having me on your show.
I
think Nigerians need to realize that this is a serious matter. I'll speak maybe later on the moral side of it, but I can just start with the constitutional argument we are making. And so I'll ask Nigerians to reference section 137(1)J. In fact, section 137 lists criteria that disqualify a candidate from contesting for the office of president. And 137(1)J specifically says that if a candidate submits a forged document, a forged certificate to INEC, then they are not, they cannot contest as president. They are disqualified. And that's the root of this journey to Chicago State University. It was to establish not whether President Tinubu attended the school or not, even though that's a conversation I think we should have. Not whether he was legally and properly admitted into that school, even though again that's a conversation I think we need to have. Not to pry necessarily into his primary and secondary school records, again, which I think is a conversation we should have. But to the fact, and not even whether he graduated, that's not the conversation. The question sought and answered in Chicago State University in that deposition was President Tinubu presented a certificate purportedly issued by Chicago State University. Is this document your document? And in the deposition, it was established that that certificate that Tinubu submitted to INEC wasn't issued by Chicago State University. And why that matters is because if President Tinubu submitted that document to INEC and the issuing authority has disavowed authorizing or issuing that document, it's a forgery. Simpliciter. It's not a criminal case. The bar is not proven beyond reasonable doubt. And even if it were, if you go to our criminal code, I think in section 345 or 346, it says if you produce a document with the intent to deceive, to profit from, it's a forgery. That's what this definition is. And so if President Tinubu, in wanting to aspire to become president, realizes that there's a bar set by our Electoral Act and our Constitution that you must provide evidence of your educational qualifications, and then willingly, deliberately, and deceitfully submit a document that wasn't issued by the Chicago State University he claims to have graduated from, then that's forgery on the face of it. You don't need a conviction. I've heard some arguments saying you need a conviction before forgery can be established. That's not true. I don't want to talk about precedent from the past. I'll talk about the precedent in this election cycle. In Kano, somebody who forged a primary school certificate, I think a House of Rep member, was removed by the tribunal and the runner-up declared validly elected. So there isn't any ambiguity about it. we will expand this conversation, I'm hoping, but that is the core of it. Section 137(1)(j) says if you submit a forged certificate to INEC, you are disqualified. And the deposition from CSU has established that the document President Tinubu submitted to INEC was a forgery. We can then start speculating where did he get it from, what was the motivation, etc., etc. Those are irrelevancies. The important thing is that, did you submit a forged certificate? You submitted a forged certificate, you stand disqualified, and that's what we are approaching the Supreme Court to rule on.
All right, that's fair enough, breaking it down like that. Let's get to you now, Mr. Destiny. As a lawyer, what I'd really like to get from you here now is that, what does this mean? What we're hearing is about the Nigerian president, is about a Nigerian presidential candidate, but it's all happening in the US. When you bring it down here, how does it factor into our own system?
And thank you for inviting me. But first of all, what I want to say is that I'm a lawyer, I deal with facts, not speculation. Assuming, but not conceding, that Atiku, he discovered what he wants to discover in the United States of America. There are so many legal impediments that he has to face before that matter can even be discussed on merit in Nigeria. Number one, those documents, those depositions, they were made pursuant to a judgment of a district court, which is likened to an area court in Nigeria. Again, you must look at the Foreign Judgment Enforcement Act, which is the statutes guiding how foreign judgment is to be litigated upon in Nigeria. First of all, those documents will have to be registered in Nigeria via motion in a federal high court and litigated upon. Now, if that one is established, you have to come to the time frame, the constitutional time frame, before the Supreme Court can decide that matter, which is 60 days. Constitutional time frame, which is like what we call is like a rock of Gibraltar. It cannot be extended even by a day. And again, if you allege forgery, you must prove it beyond reasonable doubt that this person has actually committed a fraud. Then the big one, the biggest biggest hurdle they will face is the issue of the time frame for presenting particulars and your grounds of petition. A meticulous look at PDP petition, he never raises the issue of forgery. Never, not even a single line that they raised the issue of forgery, or they were manifest inconsistency between all his documents he presented to INEC. Now, in our electoral jurisprudence, once you have filed your election petition, you have filed your petition against a candidate declared winner by the electoral umpire, you cannot bring in new facts as in these circumstances to say maybe during the time of litigation with that one constitutional 180 days the court of first instance bring in new facts again. No, the law doesn't allow that.
In no instance?
At no instance at all. The law does not allow that. Now, upon APC response to PDP's petition, I don't know, maybe it's the media, they said the man is a serial loser. And PDP started bringing the Guinea passport, that he's not even in Nigeria. And that was what the Court of Appeal struck out, that this thing, it amounts to amendment of the constitution, of the election petition. So you cannot amend. And again, the appellant brief filed by PDP. Now, the issue of forgery, inconsistency, was not part of it. Election petition be a sui generis matter. You cannot bring in new facts. The door is closed. It's shut and sealed against bringing new facts. So no matter the circumstances, and again, even though the law, what the law even permits in civil proceedings, not even electoral proceedings, so in civil proceedings, that these issues, these particulars, were fair raised at the court of first instance. Because of impracticability, you were not able to get this judgment. You understand me? You were not able to get this judgment. This issue was not in any way raised at the lower court.
But
no, it's not for. There's so many legal impediments, and the issue of academic qualification is a pre-election matter. I'm speaking from the point of law. The only party that has a locus, the legal right to challenge the academic qualification, is an aspirant in APC. Within 14 days, which he must file, is a pre-election matter.
Back then,
not now. So electoral courts, their mandate is to decide whether votes were properly allocated, whether vote casted for a particular candidate is the truest vote scored by him at the election. That is the constitutional function of a tribunal.
Well, it almost seems as though you've, based on these impediments, as though it's not going anywhere. But then, the former vice president has his own legal team.
Of course.
Are you saying they were not aware that there isn't some way that this could be, or a case could be made for it to be added to their Supreme Court filing? As
it is now, let me tell you, election matters is sui generis. Sui generis means that it's of a particular kind. It has its own rules. Its own rules, let me use the word, they are rigid. Straight away, they are rigid. You can't bend it. You understand? Because if you are to establish the issue of forgery, the police have to be involved. Before you conclude all this, Emperor, the constitutional time for the Supreme Court, the apex court, to decide the matter must have elapsed by a fraction of time. So as it is now, I use the word the door is sealed. The word the door is sealed. There's nothing they can do. I don't accept the Supreme Court to decide, because sometimes you can raise the argument that fraud vitiates everything. But how will you bring this fact in when it was not in your petition? I'm not talking speculating on the fact whether whether he actually forged a certificate, but no. I'm just saying that it does not form part of your petition. At the first instance, 21 days after the result was declared. So you cannot bring it, and Supreme Court, they will not even listen to you. Except in rare cases, maybe they may decide to depart from their notorious no principle and admit fresh evidence. And where both parties will cross-examine each other. And that's unlikely in Supreme Court. That's just my take.
All right, let's bring on Mr. Ose back in. I still have some questions for you, but let's just bring it back into the conversation. I would give a basic definition of forgery.
Before you bring me back,
okay.
You introduced me as a PDP member and a policy analyst. And I spoke in the first opening segment as a policy analyst. I introduced my barrister friend here as a lawyer. And he spoke as an APC member. I didn't interrupt you, sir.
Okay.
He spoke as an APC member. He spoke as an interested party, which I am. And I think it would have helped put context to the conversation if I had known it was not going to be an objective conversation. And so I'm forced to respond. Because if an objective lawyer comes here and calls my candidate a serial loser, that's not the law. So I'm going to respond to him appropriately. I hate people that come here to deceive. When you talk about sui generis, you talk about the uniqueness of that case. It's not rigid, the law. Sui generis does not impact rigidity. If in criminal law, for instance, the bar of forgery is a criminal case, and you have to prove culpability beyond reasonable doubt. In an electoral matter, because it is sui generis, these same concepts take a unique and different perspective. So why a lawyer will come on a public national platform and say that you cannot contest the candidacy of or qualification of a candidate after the elections, it's mind-boggling. Do you want me to reel out how many people have lost their... I just talked about Kanu and the person that was disqualified because of his primary school certificate. Is he insulting the integrity of those judges, that he knows the law more than them? Do you remember how PDP lost the election in Bayelsa State at the ballot and was awarded it at the tribunal and the Supreme Court because the De Villeron deputy had discrepancies in his certificate? Is he saying he knows the law more than... I don't appreciate these types of conversations that come here with dishonesty. Before this conversation, my friend was talking about Obaseki and how the APC took him to court with a discrepancy in his name. And the court said it's only the issuing authority that can make a determination. And the determination was made by his university. The court did not say it's a pre-election matter. And that's why Obaseki is in government house. So I'll try and stick to the issues. A lawyer will come on national television and say the Supreme Court cannot admit new evidence. When we have settled cases, election cases, when he knows Order 212 allows the Supreme Court discretion to admit new cases. We can talk politics. I'm more than competent and capable to talk partisan politics. But to come and say it doesn't matter, whether he forged, he doesn't forge, let us speak to the law, and then you start bringing in partisan arguments that I heard the other day from the National Publicity Secretary of the APC. It's a little bit dishonest, and I would much more prefer we say this is a party conversation. Let's discuss the party. Let's discuss party argument. But if we are going to discuss the law, let us discuss the law. And the Constitution says, Section 137(1)(j), once you submit a forged certificate to INEC, you are disqualified. My brother probably has not read the PDP petition, because if he had read it, I don't know why. Even if he had read the PDP petition, he had read APC's responses, he had read the final judgment, he would say the issue of certificate forgery was not raised. APC responded. Wale Olopekun submitted certificate copies from Chicago State University to the tribunal. And he submitted it in response to our arguments that Chicago State University document submitted was a forgery. Look, I'm not a trivial person. I have read every single word of the petition, so I can tell you what happened in the judgment. I can tell you that the petitioners said those our grounds for when we argued that President Tinubu was not validly elected because he was not qualified. The petitioners argued that it was vague, and the tribunal agreed with them, and we are going to the Supreme Court to challenge it because we dispensed of that cloak of vagueness in our arguments. So please let nobody come here and misrepresent the truth. It's something I do. If we were having a partisan argument, I can banter with my friend. If we're having a legal argument, we should face the law. But I don't like this misrepresentation where somebody will come and try and ambush me. A lawyer speaking to facts will not come on a national television and call Atiku a serial loser. So if you are speaking to facts, withdraw that statement. If you are not and you are representing the APC, let's proceed.
No, I think you are missing it. But I don't like when you begin to make the Supreme Court. No, listen.
The Supreme Court away from being an appellate court. The Supreme Court, away from being an appellate court, is a court of public policy. And they have ruled and reprimanded tribunal judges who use technicalities to deny petitioner justice. So for anybody here to come and try and present what the Supreme Court is going to do, a lawyer will not do that. I am not a lawyer. I will not tell you which way the Supreme Court is going to roll. I will not tell you that they will admit new evidence. I will tell you that we hope our petition is compelling enough to prompt them to admit it. For a lawyer to come and start speaking on behalf of the Supreme Court, I'm scandalized, my friend.
No. I think you are missing the
I am not missing anything.
I take exception to that your word. When you made all my submissions as
you have no exception to take.
I take exception to that. What I said is that because of the way APC responded, they called him a serial loser. Did I say he's a serial loser? I never said that. Law is not emotion. I'm talking based on existing principles of law, not my own. I don't have interest in the matter. I don't have interest in the matter. What I am saying is that PDP's petition, the grounds, the particulars of forgery, was not part of the petition at the first instance. Therefore, under established principles of law, they cannot bring down issues at the Supreme Court. Those are the established principles of law.
But just to add, if you recall, I said I had some questions for you, but I wanted him to come in first. There is a part where the court did dismiss the PDP's allegations of forgery leveled against President Bola Tinubu.
Yeah.
This is part of the PDP case.
No. What the ground that the court dismissed that it does not form part of the petition. At the petition they brought in, that 21 days, it was not part of the petition. It was when APC responded that in their reply, they raised those issues. And you can't put something on nothing.
So what was the APC replying to?
APC was replying to the issues of 25%.
Okay.
25%, then non-compliance, and I think Abuja, another thing. That was what Shetima's qualification. That was what they replied to. And in law, you can't raise new issue in your reply. That is the law. I'm telling you, that is the law. I'm not an APC member. I'm going to say these are the established principles of law.
I just have to, at some point while you were talking, you didn't say that except the Supreme Court decides.
So decide.
So that is not completely, out of.
Even this, my brother, he's here accusing me that I say this is how this. I never said that. I said except the court so decide.
So that means there is a pathway.
Law is not mathematics. Law is not mathematics. Law, it's according to the peculiarity of the fact. A case is an authority for what is decided. But as far as I'm concerned, the established principles of law, Supreme Court don't admit fresh evidence that will warrant for cross-examination. More so, these issues were not raised timelessly within the constitutional and the electoral time of raising those issues. So what I'm saying is that the Supreme Court cannot litigate on it based on established principle of except they so decide. What the laws is that they cannot admit fresh evidence, but they have the power. But again, the section order 2 of the Supreme Court rules that people are erroneously quoting, it does not apply here. It only applies to civil proceedings. Electoral matter have its own they have its own rules. They play according to the rules. So order 2 does not even come in of the Supreme Court. It does not even come in. Like I said, the court have the inherent power under section 6 to admit evidence. But based on established principles of law, Supreme Court is unlikely to admit fresh evidence of matter that was not even raised at the lower court.
Just one more thing, before we move. I just want to, reiterate what he said, and I want to respond well to it. Again, it says that that particular issue was ruled out or was removed because the PDP failed to provide evidence to support their claims. It doesn't really say that it wasn't raised initially.
No.
So I'm a bit confused as to that because when you say it wasn't raised.
What I'm saying is that the issues of forgeries, discrepancies, inconsistencies with his academic credentials, they were not raised timelessly in the original petition presented to the Court of Appeal. It is when APC replied, from what I heard, they call him a serial loser, that they decided to bring him that he is also he's a forger, things like that, and they brought all these facts, these particulars. And Court of Appeal, rightly, correctly in law, said, no, you can't put something on nothing. You can only make further particulars if in your original petition that these issues were raised. So on that ground, they struck it out. And again, they went into the merit of the matter. And they said that there were not enough particulars to support it. We did not subpoena Chicago State University to testify. So both on merit and both on in law, that fact, they were expunged. You should understand it. This is law. I'm not an APC member. I'm not a politician. This is law. So those facts, they were expunged. Now at the Supreme Court, what they are going to look at is the petition you forwarded to the court.
Not the case in entirety.
No, they will look at it. They will look at the starting point is the petition. The starting point is the petition. Now the petition you brought to court, were there issues of forgery? That is the question. Were there issues of forgery?
All right, let me allow one more time.
Don't look at it as a very combat. I'm not speaking from the prism of the law. I said assuming. What I said, assuming but not conceding. He faces so many legal impediments for the matter to even be discussed at the Supreme Court.
Right. These are established. I don't know if Sir wants to respond to that, but after we do, I'd like you to answer to the issue here of forgery. I wanted to give you a very basic definition of forgery, but the question is, so far from everything you've seen, do you think I was about to say your client, pardon me, your candidate has
call him my client.
Your candidate has he been able to establish that?
So I think now that we have the context of, I have a better sense of the conversation we're having. We can move forward. I'm not going to speak for the Supreme Court. Again, the Supreme Court has the discretion to act because it's a court of public policy. The Supreme Court is like a court of law. So Supreme Court cases, when ruled on, become law. So it can choose to go left or go right. And we hope, on the face of fresh evidence we have produced, we have acquired, that we were unable to acquire, if not for the fact that we contested against Tinubu and we are going to Supreme Court. Because America has this fair power law that protects very, very vigorously the privacy rights with regards to educations of people who school in America. So the bar to access those records was very, very high. And it was only because of Atiku's current status as a petitioner that he was able to, first of all, approach the courts. And you had to prove you needed the information for use in a foreign jurisdiction, which is what obviously we need because we are approaching the Supreme Court. So it wasn't something we could have gotten before the elections. So when a lot of people say, why didn't we get it before? It wasn't possible. US laws would have restricted us from getting it. But now that we have gotten it, it has been established. I want to read, like I said, election petitions are different from, as sui generis, let's use that word, are different from normal cases. But let me read the definition in our section 346 of how the criminal code defines forgery. It says a person who produces a false document or writing knowing it to be false and with intent that it may be used in a way and acted upon as genuine, whether in the state or elsewhere, to the prejudice or disadvantage of any person or with intent that any person may, in the belief that it is genuine, be induced to do or refrain from doing any act, whether in the state or elsewhere, is said to forge the document in writing. It doesn't talk about attending schools. It doesn't talk about graduating. It talks about producing a document you know to be false with the intent to deceive. We have, under oath, deposed Chicago State University. And under oath, they have said that the document President Tinubu submitted to INEC was not issued by them. They did not authorize any third party to issue that document to President Tinubu. It is therefore a forgery. simplicity. I'm not looking into, and I'm not interested in intent, mens rea, or actual. I'm not interested in that. If you recall with Shetima and the APM petition, when APM pushed for double nomination, the tribunal said it may have happened without his knowledge. It may have happened unknowingly. Yeah. And why they were able to say that was that the Electoral Act says in that clause about double nomination, a person who knowingly allows himself to be nominated in more than one constituency. Yeah. There is no such provision in section 137(1)(g). Once you present it, a forged document, you are disqualified. And that for us is the start and end of this conversation. I have heard, I don't know if you've been following the conversation, in national conversation, and you have seen some PDP spokespeople, you have seen some lawyers saying that you cannot build anything on nothing. And they make that statement because they trace Tinubu's admission back to statements that were false on the face of it. So, for instance, in his admission to Southwest University, he claims that he attended Government College, Lagos, and graduated in 1970. Government College, Lagos was not established in 1974. So, again, I'm talking about documents presented by CSU under oath in their deposition. And so you have evidence of falsehood that led to his admission to Southwest University, that allowed him get into CSU, that allowed him attend and graduate and purport to present a certificate. You cannot build something on nothing. And this string of illegalities goes back all the way to 1999, where President Tinubu in an INEC, I have run for election. You swear oaths when you submit those documents to INEC. It's an affidavit, sworn under oath. President Tinubu said he attended a primary school. He didn't produce any evidence. Says he attended Government College Ibadan. We've now shifted 25 years later to Government College Lagos. And so you have, again, a serial of inconsistencies and perjurious statements and forgery. I want to now come on air and use technicalities to dismiss it. For me personally, I will never forget, anytime I go on television, I always talk about Salisu Buhari. He was our first speaker in this dispensation, who I think forged, was it Toronto or Chicago? He did forge something, either his age or something, and was forced to resign. And he said, in resigning, that he hopes his public humiliation will be the building blocks of a better Nigeria where this type of thing will not happen again. Because of Salisu Buhari, I went to NYSC twice. I started my service. I got admission in my 10th month to study abroad. I terminated my youth service, went to do my master's, came back and served again a full year. Because the society we were building at the time was one where if your name was Evan Enwerem, and you have a document saying Evans Enwerem, even if you were the president of the Senate, which he was, you will be forced to step down because society did not condone forgery, did not condone it, the whiff of it. But we are now, so that's why I served, because I knew I wanted to get into public office and I didn't want to be embarrassed or humiliated. But we are now in a situation where lawyers and Nigerians will come and use legalese and technicalities to try and deodorize a dump heap, where we have a serving minister who is a youth copper, where we have a president who we've established submitted a forged document to INEC. And how is that okay? That is the type of society we want to build? I don't think so. And so if I'm passionate, I think I have every right to be passionate, because these things are scandalous and we should all condemn it. The basis of any conversation should be the condemnation of this nonsense that is going on. before any other conversation can proceed.
All right, Mr. Destiny, I'd just like to point out again, the deposition, as is said repeatedly, the persons who were supposed to have issued that certificate said this particular certificate that has been submitted to INEC is not from us. Is that not the all and every? Is there more to it?
So let me tell you, in criminal law, under our criminal jurisprudence, the scale is that in a criminal proceeding, it must be proven beyond reasonable doubt. I'm very careful not to speak on the what I call speculation. The fact is that, is there a case of forgery, a document convincing, cogent, like a court document saying that you have forged certificate, that certificate is forged? You know, you must look at it legally. I'm not looking at it based on fact. I'm looking at it legally from the point of law. If you are coming to the Supreme Court, let's even assume that Supreme Court decides to open the door for fresh evidence. No, that document that is available to you pursuant to an area court, which is a court of a district of Illinois, something like that, is an area court under the Foreign Judgment Enforcement Act. These are facts. Before you can bring in those documents, it must first be registered in Nigeria and litigated upon via motion in Federal High Court, and it must be conclusive it must be a judgment from a high court, not an area court. You know, so it is before forgery. You know, as a lawyer, the police have to be involved, the FBI have to be involved, even the school have to be involved, the party have to be involved before they can say you have been convicted.
So sorry,
listen.
Okay.
Before you can bring you this document, they say, "Oh, my lord, we have a case of conviction. This person was convicted, and he was sentenced to so many years." In response to that one, I'm just speaking of the fact. What a court is concerned about is the genuity of the certificates you presented to court. The court is not a forensic laboratory that will inquire how you got admission into university. What is that? The certificate is presented, is genuine, is from the issuing authority. The issuing authority says that you graduated from their school. That is what a court is concerned with. I'm just telling you the workings of the court with established principles of law. The court look at the document, not how you got admission into university.
Well, when you say established principle of law, certainly this wouldn't be the first case of an attempt to prove forgery and it removing an officer, of the government. So the question is, what you've established now, are you saying this is how it was established everywhere else? Take for instance, no instance immediately comes to mind, but the point I'm making is, you seem to be making a case that there has to be some sort of case that involves police and all of that.
Very well, that's law.
All the time when it comes to forgery, is that what you're saying?
That's how it is.
So all the persons that have been...
Allegation of forgery is a very weighty and serious offense. So it must be proven beyond reasonable doubt with a conviction.
The question is, when the issuer says I didn't issue it, is there still doubt? I don't know. I'm a little bit...
That, I'm not looking at the disposition at all. I'm just taking it because that's the statement of fact.
That's what?
I'm not looking at the disposition because people can give it different coloration. I'm talking of what is agreed. What is agreed, and this is what is it. This is the, I'm speaking the law on acceptable fact. Acceptable fact is that let's even assume that you have documents that's been given to you. I'm saying that before those documents can find its way to Nigeria court, this is what you have to do. So the only established fact to prove forgery, not just forgery, criminal offense, that it follows a conviction. It must follows a conviction. That is what establishes forgery, a criminal. Because you can't say it's a criminal offense. Now then, is a criminal offense. Based on what somebody said, it means that person has fraud certificate. No, you must take that person to court, get him convicted by a court of competent jurisdiction before the case of forgery can be against that person.
Well, Amadi, whilst this conversation is going on, like I said, I don't want to go too far, so I don't want to talk about Bayelsa, right, where an elected government was removed because the deputy forged the documents. We didn't approach...
Riddled with inconsistency.
We didn't approach a court. We didn't get a conviction, right? We started this conversation with my lawyer friend talking about electoral cases being sui generis. And then to defend the indefensible, he is now using criminal code as the bar to set for what he had said was sui generis. Whilst we're talking, I want you to check Kano primary state NNPP removed. We have in this election cycle, some weeks ago, a Kano state lawmaker elected was removed because he forged his primary school certificate. He wasn't convicted. No conviction was presented to the court. Just evidence on the face of it that he had forged his primary school certificate. That's all. That is all. It wasn't even about whether he was educated, because he's an educated man. He has university degrees, I think, and the rest. But the law says once you submit a fraud document to INEC, you are disqualified. So if that is the law, and we have judgments and settled cases where this has been established, where forgers have been removed and their mandates handed to somebody else, why would any lawyer who is not pushing an agenda come on a national platform and say the only way you can remove a certificate forger is by going and getting a conviction in a criminal court and coming to show the court? What are we talking about? In the Obaseki case, the tribunal ruled, the court ruled that it is the issuing authority, only the issuing authority that can determine whether that certificate was validly issued by them or not. And we have gone to, because they are judicial precedents, and that is why we didn't approach a forensic expert, because the discrepancies would have been easy to determine. But because of settled case law, we went to the issuing authority, who stated under oath, it wasn't a trivial matter, it wasn't a statement of fact, it was under oath, that document President Tinubu submitted did not emanate from them. And then, we see this attempt to put legal obstacles in the face of what is now established fact, that the document President Tinubu submitted to INEC was forged. It boggles my mind. And you say you're looking at it based on facts. What are the facts before us? You know the fact, Amadi. You read the deposition, just as I have. Okay. And you know the fact is that...
You know what?
My brother, let me finish.
No, you are missing it. He's not a lawyer. What does it mean that? Once you swear in an affidavit...
My brother, when I finish, Chicago State University swore an affidavit. And we were unsatisfied by it, and that is why we held an oral deposition to even query those statements that were made in the affidavit, to get clarity on what you said. If you swear an affidavit and it is found that you put out false information, you have perjured yourself. You perjured yourself. So if you look at the affidavit that Tinubu submitted to INEC, for instance, where he says he had not taken up any foreign nationality. If you look at the CSU document, it's ticked that he's a US national. So we have somebody who, and again, why I don't want to go into perjury is because it's not relevant to his qualification as president of Nigeria. I would concede to my lawyer friend that then becomes a criminal matter. If you want to sue Tinubu for perjury, go to court. That's a criminal matter. And then you have to establish, again, beyond all reasonable doubt, that he actually committed perjury. But that is not relevant to this electoral matter. What is relevant is that our Constitution says, Section 137(1)J, if you submit a forged certificate to INEC, you are disqualified. That's all we are interested in. And that has been established.
Oh.
Period.
So, Mr. Destiny, I think you wanted to respond there, but then again, you know, what he quoted there, I think, remains the issue. Because you said earlier that there has to be some sort of conviction, but then it seems it's not really stated that there has to be. I don't know. What are you referencing when you say that there has to be a conviction of some sort?
What I'm saying,
and also the examples he made, you know, what happened there?
Yes, I understand. You see, a case is an authority for what it decides. The issues of forgery is a weighty allegation. You know, it's criminal, and it must follow a criminal suit, which will end up as a conviction. That's what the law says. Like those ones he just cited, you know, of a tribunal, I'm saying that those tribunals erred in law. When you say that somebody has, I've not looked at the fact of the case of what necessitated the tribunal to say that you have forged a certificate based on what is reporting. I'm just saying that if a matter is presented to the court and you accuse somebody of forging a certificate, you don't even know whether it was a discrepancy, whether his name is Mr. Ojo in primary school, and as he was growing up, his name was now Amadu. The court can say, okay, no, this is not you. But what we are looking at is just a single document. That's a university certificate submitted by a party. And now you are saying that this document is forged. The one he submitted is forged. I'm saying before you can establish forgery, it must follow a conviction. You should understand it must follow a conviction, because the person has to be cross-examined, before you can establish a case of conviction of a forgery. It's not as easy as you are thinking. It must follow through the legal gamut.
That is to say that any case that involves forgery, the persons involved should have, in one form or another, had some conviction.
Of course, because it's done. You know, what we call beyond reasonable doubt. It must be beyond reasonable doubt that this person, you know, actually forged the certificate, and it must follow the criminal proceedings. That's how it is. It's not emotion. I'm being very careful to discover that he actually graduated from University of Chicago. I'm not discussing on those facts because they are not laws. What I'm saying is that if you want to establish a case of forgery, it must follow a criminal suit. Right. And listen. And the document you claim that is beneficial to you in USA, before you can bring it to Nigeria, first of all, it must follow the office of the Chief Justice of Nigeria, because you have to have a trace of veracity. You cannot, because otherwise, if you bring in a document from Chicago State University, your player can go and bring result from Yugoslavia or even USSR, and the Supreme Court court decide to act on it, any certificate that is brought. So what they do is that you must follow the Chief Justice office to apply for those documents through court, and the Ministry of Foreign Affairs will be we also join as a party. Before you can bring in those documents, first of all, you register it. I'm telling you, establish laws, not emotion. You register those documents. Those documents is litigated upon again, and one of the criteria you must meet that must be from a high court, Foreign Judgment Enforcement Procedures Act. That is the law.
I think he will speak to that that particular obstacle that he has repeated a couple of times. I wonder how your candidate hopes to.
That is what they should be concerned about.
Go past it, but away from that, I'd just like to read something that has started to trend. And before that, I believe we've talked about the word jurisprudence before.
Yes,
which means the cases, the sum total of cases in
the scientific study of law,
the cases,
the legal logic.
Okay, so I've seen lawyers refer to cases and say in so versus so.
That's how it works.
So in these cases, as long as they've already been adjudicated upon, can they not be referenced? I mean, the ones they mentioned with the NMPP, even the Obaseki, can't arguments be made that in so case this was said, there was no forgery, would it work that way?
No, what you have just said is the correct thing in law. There's no lawyer that will go to a court that will file a brief without mentioning one case, because you must show judicial precedent that on similar file, this is how the court reasoned.
Okay, so there is an argument.
It is how the court reasoned.
All right.
Well, no, listen.
Okay.
It is how the court reasoned that you can establish a case of forgery, just like Adams Oshomole's case, when they say he forged certificate. You must prove it beyond reasonable doubt. He has surreptitiously failed to mention the Tinubu matter. The court said that you have not proven it beyond reasonable doubt. You understand? He cited the case of NNPC, and don't give you an instance that you must prove it beyond reason. There must be sufficient particulars to establish forgery. If, for example, you have a document in USA, I say, Bola Tinubu, you are convicted for forgery. Very simple. We'll just show it to the court.
So that conviction is enough for reasonable doubt.
That's
okay. Can we talk about that? I don't know. This is just what I call a mental exercise.
Yeah.
To get that conviction.
Yes.
Would it be enough for the issuer to say I didn't issue it, and that conviction can?
No, it's not like that. It must follow a criminal proceedings.
Okay.
The police have to institute the matter.
All right.
The matter must first be investigated. Nigeria police have to be involved. FBI, the American police have to be involved. The matter will be investigated. A suit will be filed. Now, in this case, there's even a problem. Where will the suit be filed? Is it in Nigeria? Let's even assume it's in Nigeria. And again, you face another hurdle of immunity again.
Because it's the president.
It's the president.
Right.
You see, it's just legal. So, this is the truth. It's legal hurdle you need to face. I never said this is it, whether it's not forgery or it's for. I'm very careful not to state one as a partisan member. I never said, okay, since you brought this document, it has been established that it's a forgery. I'm just saying that even though you say you have a forgery, this is the mountain you will meet. The mountain that must first be registered. The mountain that it doesn't form part of your petition.
Right. Let me quickly hear from Mr. Osede. I don't know if you have the full legal aspect to this, but there's one particular obstacle he's mentioned a couple of times now, which is that the whatever happens in another country has to be brought here, and it has to start from the Federal High Court before it can get to the Supreme Court. That hurdle, is this something that your party considers to be something they need to overcome, or do you have other ways to go about it?
It is not. It is, to my mind, as relevant as submitting a foreign educational qualification from Chicago to a Nigerian institution, INEC, to allow you be qualified to contest for the office of the president. You didn't register that certificate with the Ministry of Justice and notarize it in the Ministry of Foreign Affairs. You didn't jump through those loopholes. So it's not something that we are going to assume we are going to be forced to jump into because APC handlers feel that that's the way to go right now. If Tinubu had, before he was allowed to submit that document in INEC, had gone through that process, then it would make sense to me. Logically, it would make sense. But if you say, based on the word of Chicago State University, you are qualified under our Constitution and Electoral Act to run for president, then based on the word of Chicago State University, you are not qualified. It's as simple as that. So when they bring this illogical gymnastics, it's easy to battle with. It's very, very easy to battle with. Any mountains, legal or otherwise, that are in front of us, we will meet them and will overcome them. It's not for my. Don't swallow Panadol for our headache. I beg of you.
Okay.
To the Enugu matter, again, I follow the Enugu matter because I'm a PDP member, and I personally had issues with that judgment. The courts did not rule that you need a criminal conviction in dismissing it. They ruled on the merit of the matter and said a case of forgery was not established. They didn't say it wasn't established beyond reasonable doubt. They didn't say Labour didn't provide a conviction in a court, in a lower court. And where they even, to my mind, even went wrong was that they made a very curious argument which is something that I even suspect they made because it might be something that they want to use in the presidential election. The bar for qualification is WAEC, and INEC goes further in the Constitution. It goes further to interpret what that means, to mean being able to read and write, being educated up to primary school, and maybe having served in the public service for 10 years or whatever. There are various bars. It's not stricto sensu a WAEC certificate. It's just
very correct.
Being educated enough to satisfy INEC, right? But the Enugu Tribunal now says that even if they had found that the WAEC certificate was forged, because it is not a criteria for qualification, so you don't need NYSC to become governor, it doesn't matter whether it was forged or not, which is very curious. Again, because if you read section 137(1)(j), it speaks simply about presenting a certificate. And an NYSC document is a certificate. It speaks simply about presenting a certificate to INEC, which is why the Kanu NNPP representative was disqualified, because he didn't present a fake WAEC certificate, but he presented a false primary school leaving certificate, and he was disqualified. So I worry about our judiciary and the fact that you cannot, on the face of the argument, predict which way the outcome will be. I think it's very, very worrying. Most people who followed the case in the US courts got a sense of transparency and certainty and surety that this is what is going to happen. The language was unambiguous. I read the Supreme Court judgment, the tribunal judgment on the presidential election petition was about 800 pages. It was very, 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 very short. These are the issues of determination. These are the arguments. This is my ruling. It didn't take 180 days. It took barely weeks. And I think, because I always try to speak, let me put away my partisan hat. I always try to speak as a nationalist, as a Democrat. Our nation is built on myths. There's no physical structure holding us up. It's belief in the power of the executive, it's belief in our legislature as our representatives, and it's in belief that our judiciary will serve justice if any wrongdoing happens to any one of us. And when you start to see doubts in these institutions, the foundations of your nation, of nationhood, of that sense, that identity of being a Nigerian and of Nigeria itself, start to crumble. That's why I'm so passionate about these things. It doesn't matter. Every single time I've referred to Tinubu, I have called him President Tinubu, because our laws say that he has been validly elected. And until the Supreme Court or any other court overturns it, he's our president. And you must recognize that fact, whether you agree with it or not. And so I worry when I see attempts to erode confidence in these myths. And that's why I'm fighting very passionately against that. We must again reject it. We must reject it. And we must hope that the Supreme Court will serve as a court of public policy and not use a technicality to deny Nigerians justice.
Right. I believe you've made your stance very clear. Mr. Destiny, if we can just end the program with you. Your final words on this issue and, what you expect should happen, and how do you think the law would play out? You made a comment about how there seems to be varying
what do you call transparency?
Well, you can pick a case here and it seems to be the opposite here, and so on and so forth. So, but that being said, is there any kind of certainty you can have for such a thing, when you really don't know how it could go? Just your final statement.
Okay, like what I want to say as my final words is that a case is an authority for what it decides. What happened at Area A may not be the facts that will happen in Area B. There may be some very latent that distinguish it from the other facts that happen. So it is on that ground the court will tailor their judgment. So in this instance, but no doubt on points of law, if we want to begin to bring in moralities into our law, it must first be codified in our statute book. So once there's a law, the law must be honored to its letter.
Right.
You know, that's how it is. If you want to bring in morality, pass it through your National Assembly. The law will be there so that it can be it can be enforced. As far as the law, what you claim to be morality, it has not transmogrified into law. You are just talking fiction,
Right.
like Shakespeare.
All right, it's good to hear your words there. Let me just end this on a more political note. Since I have Salsa here, your candidate made a sort of a rallying call to the opposition to sort of join hands. The Labour Party has said that they are in court, they are fighting for their mandates, and the NNPP says they are not fighting for any mandates. So, you know, what's your take on both the call to this opposition and their response?
Okay, so I think, and you'd have gotten that sense from my conversation, I think the matters that we face are beyond partisan matters. I think they cut to the identity of the type of nation and type of society we're trying to build. You know, I mentioned the NYC youth corps who is a minister. I mentioned the fact that President Tinubu submitted a forged certificate as settled facts. And I worry that, you know, when you have these types of examples, I also give the example of what I did as a young person, watching what our leaders were doing, you know, and how that molded my life. And I worry that younger people are looking at what's playing out and are making life decisions based on flawed values that seem to permeate every space, even in the Enugu case, for instance, you know. And that's the backdrop of the call Atiku made, that this is no longer a partisan struggle, it's a national one. And so he reached out to everybody to realize that as it's a national struggle, we need to come together to fight this ill. It's no longer about PDP or APC or LP or NNPP. It's as Nigerians, this is what I believe is wrong, and I want you as leaders of huge sections of Nigerians to join me in correcting this ill. And I think in the responses from Labour and NNPP, they didn't really recognize that call for what it was and felt it was maybe come and support me to become president. And that's what guided their reaction. But just to say quickly about what my lawyer friend said about morality and the law. Our laws, our Nigerian law is, you know, you hear this Judeo-Christian, is based around Judeo-Christian values, which are religious mores and values that have been codified. So when, for instance, again, I'll go back to section 137(1)J, you have a curious law, very short law that says anybody who submits a forged certificate to INEC stands disqualified. That is morality. That is making a moral argument that this person that will do this type of thing is not qualified to lead this nation. That's a moral argument. No doubt. You can go, for instance, to the same-sex bill, that what people do in the privacy of their bedrooms. We brought it to our National Assembly because we felt it was wrong and made it law, and it was passed and stamped by government. That's a moral argument. We believe it's immoral, and so we made it law. So when you hear this oh, you know, on the face of morality you might be right, but on the face of law you're wrong, it fails to understand the origins of the law. The origins of the law were based on a distinction between right and wrong and guidance for society to follow.
All right. Thank you so much, Mr. Hussain. Thank you so much, Mr. Destiny Adiamin. It's been great having your thoughts and analysis on the matter. We'll be watching and waiting and seeing how your candidate takes this to the Supreme Court, and we'll be watching and seeing how the Supreme Court welcomes or rejects it, as the case may be. Thank you so much for coming. It's
a pleasure.
All right. That's all we can take on the program for today. Do join us every weekday. The Polity reaches you live from Abuja. See you tomorrow. I am Ahmad Tinubu. Bye for now.